Hello, everyone. So we are all set to bid adieu to the year 2022 and welcome the new year. 2022 has been quite an interesting year as several changes have been introduced in financial law sector, corporate law sector, and insolvency and bankruptcy law sector. So before wrapping up this year, we at Vinod Kothari and Company thought of giving a quick review, a quick recap of the changes that has been introduced in financial sector, corporate law sector, and insolvency and bankruptcy law sector. My colleagues have already prepared separate videos giving quick recap of financial sector and corporate law sector, and I'll be giving a quick recap of the key changes that has been introduced in the year 2022 in insolvency and bankruptcy law sector. Coming to the changes, in the year 2022, while there were no such changes in the code itself, however, there were changes in the regulations, be it liquidation regulations, CIRP regulations, or voluntary liquidation regulations, or insolvency professional regulations. There were changes introduced from time to time. Most of the changes were focused on either to provide clarity or to shrink the timeline or to fill the gap in the regulations. Now, coming to the changes that has been introduced in the IRP-CP regulations, there were 5 notifications that were introduced in the year 2022 in IRP-CP regulations. Most of the changes were, of course, with respect to shrinking the timelines for the activities to be performed during the CIRP process. However, there were certain key changes as well. One change was with respect to inviting resolution plan. Now, the resolution professionals are also empowered to invite resolution plan for one or more assets of the corporate debtor. That is to say, if the resolution plan for the corporate debt is not being received by the resolution professional within a given timeline, the resolution professional are also empowered to invite resolution plan for one or more assets of the corporate debtor. So there can be more than one resolution plan in case of one single corporate debtor. There are changes with respect to resolution plan as well, as resolution applicants are also required to provide the manner of dealing with the avoidance transaction proceedings in the resolution plan itself. There are also changes with respect to timeline for submission of information memorandum, timeline for submission of resolution plan, as these timelines have been reduced further. These regulations now also provide the fee, the minimum fee to be paid to the resolution professional. There are changes with respect to role of COC, role of resolution professional. The role has been enhanced further. There were changes with respect to contents of information memorandum, as the contents have been made more enriched so as to provide the better clarity on the state of the corporate debtor to the prospective resolution applicant. Coming to the changes that has been introduced in liquidation regulations, there were several changes in the liquidation regulations that has been introduced in the year 2022. One of the major changes was with respect to constitution of stakeholder consultation committee and role of stakeholder consultation committee. Constitution of stakeholder consultation committee is now based on the total admitted claim by the liquidator, and the voting percentage shall also be decided based on the proportionate admitted claim in the total admitted claim. As regards role of the stakeholder consultancy committee is concerned, the role is still advisory. However, it has been enhanced further so as to include the advisory with respect to fee of the liquidator and with respect to manner of dealing with the avoidance transaction proceedings post completion of the liquidation process or post completion of the dissolution of the corporate debtor, as the case may be. There were other changes as well, changes with respect to verification of claim, as the liquidator is now also required to verify the claim that were filed during the CIRP process but not filed during the liquidation process. As regards the meeting with the stakeholder consultation committee, the liquidator is now required to record the reason for deviation with the decision of stakeholder consultation committee, if any, and also to file such decision within 5 days with the adjudicating authority and insolvency and bankruptcy board of India. the changes are also required to be, the decision is also required to be filed along with the progress report. There are changes with respect to avoidance transaction proceedings as well, as the liquidator is now required to provide the details with respect to avoidance transaction proceedings, like the manner in dealing with the avoidance transaction proceedings and the manner of distribution of the realized proceeds, if any, in the liquidation, in the avoidance transaction proceedings in the final report itself. Also, as regards auction process, now the liquidator is empowered to proceed with the going concern sale in the first auction itself. If the going concern sale fails in the first auction, then the liquidator is required to opt for other options. That is to say, going concern sale will not be available with the liquidator if the first auction fails. There are changes in the voluntary liquidation regulations as well. One of the major changes is with respect to submission of declaration of solvency. Now the directors are also required to mention regarding the provision for preservation of records in the declaration of solvency itself. There are changes with respect to completion of the liquidation process when there are no creditors in the company. So now the regulation requires the liquidator to complete the liquidation process within a period of 90 days if there are no creditors in the company. Also, the regulation now requires the liquidator to provide a detailed compliance report with the adjudicating authority along with the final report and dissolution application. Also, the timeline to distribute the realized proceeds has been reduced to 30 days from the earlier 6 months. There is one major changes in the insolvency professional regulation as well, which has been introduced by Regulation 27B, which now requires the insolvency professionals, be it resolution professional or liquidator, to be personally liable, to be held personally liable for any loss or penalty that will be levied on the corporate debtor due to non-compliances of any applicable law. That is to say, if at all there will be any loss or penalty levied on the corporate debtor during the CRP process or liquidation process for any non-compliances on the with respect to the applicable law, for such loss or the penalty, the liquidator or resolution professional shall be held personally liable. This is one of the major changes that has been introduced in the insolvency law sector. There were quite a few surprises from the judiciary as well in the year 2022, as in case of Rainbow Papers Limited. Honorable Supreme Court held that by virtue of creation of security interest in favor of state government under GVAT, the state will be treated as a secure creditor within the definition of secure creditor as provided under IBC, and shall be treated at par with the secure creditors and workmen in terms of section 53(1)(b)(2) of the Insolvency and Bankruptcy Code. Another interesting ruling was with in the matter of Vaidharba Industry Power Limited versus Axis Bank of India Limited, wherein Honorable Supreme Court held that the provision of section 7(5)(a) of the Insolvency Bankruptcy Code is discretionary in nature. That is to say, the insolvency proceedings against a corporate debtor cannot be initiated merely on account of temporary inability to pay financial debts. Another interesting ruling was in the matter of Sunil Kumar Jain versus Sudarshan Bhatt, wherein Honorable Supreme Court held that salary or wages payable to an employee or workman of a corporate debtor for CRP period shall be included in the CRP cost only if it is established that the corporate debtor was going concern during the CRP period and that the workman or employee claiming their dues for the CRP period have actually worked during that CRP process. There was one more interesting ruling in case of PTC India Financial Services Limited, wherein Honorable Supreme Court extensively reviewed the law on pledges and clarified the right of the parties in the context of pledge created on demat shares. Thus, there were several changes. There are other Supreme Court rulings as well, details of which we have summarized. I'll be giving a link of the summary judgments of Supreme Court passed in the year 2022 in the description box below. obviously one has to acknowledge the fact that the very reason for introducing these amendments is to reduce the timeline for the activities to be performed during CIRP process or liquidation process. However, one also has to acknowledge the fact that one of the very reason for the inordinate delay in completion of the process, be it CIRP process or liquidation process, is the adjudication is a pending or adjudication proceedings, given that NCLT benches are overburdened with the vexatious matters or matters that do not require the NCLT proceedings. It is very important to declog the NCLT from such kind of matters, such that NCLT can focus on the core matter and the overall objective of IBC can be achieved. Thank you.